hey, it's not the middle of the night. I'm in a study room, so I might get cut off and get kicked out because you're supposed to have two, and I didn't reserve it because I don't have two people. It's okay. So we're gonna do interpretation, and then the next video will be parole evidence, but I'll probably break it up into two. We'll see how long this goes. So for this, principles of interpretation. Oh, let me show you this bee. This is the bee I made for Pepperdine. So cute. Okay, principles of interpretation. What's the theory of interpreting contracts? And it's there's a couple theories. One is purely subjective, and the courts that use that are looking at what people thought it meant. So this is the Peerless case where there was a ship and two ships had the same name and they were about a month apart, and one thought they meant one Peerless and one thought they meant the other. But this gives the people drafting the contracts autonomy, but different subject understandings of the contract mean there was no meeting of the minds. So Peerless and Peerless, there wasn't a meeting of the minds there. They thought they were in different worlds. And then, so that's subjective. The objective is what a reasonable person would interpret, but sometimes it's what no one thought that's easier to enforce. So what would a reasonable person think? And like the two contracting parties didn't think that. So we should only care about how a reasonable person would interpret the words. That's what the objective view is saying. And they say using subjective intent would make contracts hard to enforce, and people would realize that words will be defined by their normal usage. And the issue here is a contract could mean what neither party wanted, which would be crazy for a court to be like, well, this is what we're going to do. And they're like, what? Neither one of us. But then there is the hybrid theory, and this is the restatement theory. And that is whose meaning prevails. So in the hybrid theory, you're going to use a little bit of both the objective and the subjective, and they're going to look at where the parties have attached the same meaning to a promise or agreement or the term thereof. It is going to be interpreted in accordance with that meaning, which totally makes sense. And then where the parties have attached different meanings to a promise or agreement or term thereof, it is interpreted in accordance with the meaning attached by one of them if at the time of the agreement that party did not know any different meaning attached by the other, and the other knew that this one had a different meaning, or that the party had no reason to know any different meaning attached by the other, and the other at least had a reason to know the meaning attached to the first party. Ordinarily, a party will have reason to know the meaning of generally used words. So if you're going to use a different meaning, you should know that that's what they're doing. Except as stated in this section, neither party is bound by the meaning attached by the other, even though the result may be failure of mutual assent. So barring those like you knew or you had reason to know, it's going to be a failure of mutual assent. Comment D says misunderstanding, and where the rules stated in subsections 1 and 2 do not apply, neither party is bound by the understanding of the other. The result may be an entire failure of the agreement or a failure to agree as to a term. So it could be no mutual assent to the contract, or it could be just no mutual assent to those particular terms of the contract. There may be a binding contract despite failure to agree as to a term if the term is not essential or if it can be supplied. So there might be some surgery going on, but if it's a material term, then it will probably be no contract here. This happened in Joyner v. Adams, and this was the development. So he was supposed to develop the land, and he did, but he did not like build all the buildings. And it came down to like, well, we thought development meant this, and like the trade usage for the word of development does agree with that. So reason to know, did they have reason to know? Did they know? Or was there just no mutual assent? So this is the application of the 201 restatement of the hybrid subjective objective. And this is different subjective intent of the parties can lead to no meeting of the minds. Did the parties know or have reason to know of the other parties? And the court said they did. The other thing that could have gotten them into trouble was the drafter was the party, was the defendant. And so, so this is Restatement 206, and it says, in choosing among the reasonable meanings of a promise or agreement or term thereof, that meaning is generally preferred, which operates against the party who supplies the words for the writing. So if you're the writer, you have more power. And so if you wrote the wrong words and it didn't make sense, it's probably going to be construed against you. And in this case, that could have happened too, except that they did use kind of the standard trade usage, and also both parties engaged in arm's length negotiations. So even though one wrote it, there was the opportunity for both to be involved, and that just didn't happen. And the rationale is comment A of 206, and it says, where one party chooses the term of the contract, he is likely to provide more carefully for the protection of his own interests than for those of the other party. He is also more likely than the other party to have reason to know of uncertainties of meaning. Indeed, he may leave meaning deliberately obscure, intending to decide at a later date what meaning to assert. In cases of doubt, therefore, so long as other factors are not decisive, there is substantial reason for preferring the meaning of the other party. So you're going to look at all of the circumstances surrounding to interpret, because this is interpretation. Okay, and the Restatement 201 says, the problem of context. Uncertainties in the meaning of words are ordinarily greatly reduced by the context in which they are used. In general, the context relevant to interpretation of a bargain is the context common to both parties. More precisely, the question of meaning in cases of misunderstanding depends on inquiry into what each party knew or had reason to know, as stated in subsections 2 or 3. Ordinarily, a party has reason to know of meanings in general usage. In the case we just talked about, the joiner, it was in the joiner case. They bring in like what's the normal usage, what has been done before. We're gonna get to the chicken case next. Okay, Restatement 202, aids of interpretation. So how are we going to figure this out? Exactly what we just said. When does someone have reason to know? Words and other conduct are interpreted in light of all the circumstances, and if the principal purpose of the parties is ascertainable, it is given great weight. A writing is interpreted as a whole, and all writings that are part of the same transaction are interpreted together, unless a different intention is manifested. So where language has a generally prevailing meaning, it is interpreted in accordance with that meaning. So if I say sky, I mean the thing up there. I probably don't mean the ground, unless I told you that before. Technical terms and words of art are given their technical meaning when used in a transaction within their technical field. Trade usage puts one on notice that they should know if it's a common trade usage term. Where an agreement involves repeated occasions for performance by either party with knowledge of the nature of the performance and opportunity for objection to it by the other, any course of performance accepted or acquiesced in without objection is giving great weight in the interpretation of the agreement. So if we've been working on this contract and you've never said no, that's gonna give evidence that it was okay, it was agreed to, it was acquiesced. This is called course of dealings, and it's about the conduct between both parties on one contract. And then kind of similar, but wherever reasonable, the manifestations of intention of the parties to a promise or agreement are interpreted as consistent with each other and with any relevant course of performance, course of dealing, or usage in trade. So this is based on past performance, so other contracts. So course of dealings is one contract, and past performance is multiple contracts. Okay, this case, Restatement and BNS International, otherwise known as the chicken case. So plaintiff has the burden of showing that chicken was used in the narrow rather than the broad sense, And in this case, the plaintiff was not able to do that. They had lots of evidence of how it's used and when it's used and why it's used and blah, blah, blah. But there was the plaintiff couldn't show like why exactly it was only this, like in all of the evidence, why this one, and they couldn't meet their burden. But they do need to use the aids of interpretation, which we just talked about, and there's a hierarchy of them. So from best to least, you're going to look at course of performance. So if it's already been acquiesced to in the contract, like that's going to be your strongest evidence. And then trade usage is your second because it puts you on notice. It fits right into that restatement that you either know or have reason to know. And then third is course of dealings. I know for the past 3 contracts with you, blah, blah, blah. And they each have their different restatements. And kind of funny because it goes up the ladder. So 202 says repeated occasions for performance by either party with knowledge of the nature of the performance and opportunity for objection to it by the other. That's 202, course of performance. And then trade usage is 222, having such regularity of observance in a place, vocation, or trade as to justify an expectation that it will be observed with respect to a particular agreement. And then 223, course of dealings, a sequence of previous conduct between the parties to an agreement which is fairly to be regarded as establishing a common basis of understanding for interpreting their expression and other conduct. Course of performance, trade usage, course of dealing. And last but not least, in interpretation, ambiguity. So under common law, courts often say that the need to interpret a provision only arises if there is more than one reasonable meaning for a provision. Okay, if a term is only susceptible to one meaning, then there's nothing to interpret. To figure out whether there is any need for interpretation, most courts require ambiguity. So some could say chicken is not ambiguous, but then it was. If a provision is ambiguous, then there is something to interpret. Under this analysis, courts first must find that the term is ambiguous. So that's 1, is the term ambiguous? And 2, if it is ambiguous, then a court can allow the fact finder, often a jury, to interpret the term, and that would be based on the evidence that we showed. Restatement 202, comment A. 202 is about the course of performance. It says the scope of special rules. The rules in this section are applicable to all manifestations of intentions in all transactions. The rules are general in character and serve merely as guides in the process of interpretation. Bolded. They do not depend upon any determination that there is ambiguity, but are used in determining what meanings are reasonably possible, as well as choosing among possible meanings. So sounds like so some courts say there must be ambiguity. The restatement says they don't. So you have 2 paths. And on an exam, you're going to have to take both paths. All right, up next is parole evidence. So see you next time.